All right, Monday morning, and there's already a story tearing through political circles that most major outlets haven't even caught up to yet. Dr. Raymond Ashford, personal physician to Senator Marcus Whitfield for nearly 3 decades, just had his medical license stripped by unanimous vote. The filing landed Saturday. I've spent the weekend combing through all 94 pages of it, and what I found is a lot messier and a lot more interesting than the headlines are letting on. Here's the number that jumped out first: $2.6 million. 51 patients, records quietly funneled to people who had absolutely no business seeing them over a stretch of roughly 2 years. Medical boards don't pull a license like this on a whim. The last comparable case in this state happened back in 2018. 9 years of practicing medicine, gone in a single vote. You've probably seen the surface level headlines by now. I want to walk you through what the actual filing says, because it's a very different story once you get past the summary. Quick background for anyone just tuning in. Dr. Raymond Ashford served as Senator Marcus Whitfield's personal physician from the early 1990s, all the way through 2021. This is the same doctor who years ago penned that now infamous letter proclaiming Whitfield to be, in his words, the picture of extraordinary vitality for a man of his age. That letter got mocked across the medical community at the time for how over the top it sounded. The current issue has nothing to do with that old letter directly, but it does connect to a pattern the board says stretches back further than anyone realized. The core allegation: systematic, repeated violations of patient confidentiality on a scale the board's own language describes as extraordinary in both frequency and intent. Let me give you the fast version before we get into the documents themselves. Late 2023, an internal audit at Kingsbridge Memorial Hospital flags unusual patterns in how patient files were being accessed. Spring 2024, a handful of former patients file formal complaints with the state medical board. By autumn 2024, subpoenas go out for electronic health records. Depositions begin in early 2025. By this year, the investigation has ballooned to cover 51 separate patients. And this past Friday, the board votes to pull Ashford's license entirely. That's the skeleton. But here's what actually makes this case different from a routine ethics violation. This wasn't some external hacking incident. Nobody stole a laptop. Nobody broke into a server room. According to the board's own findings, every single instance of unauthorized access was deliberate, repeated, and in several cases tied to specific requests from parties the board still won't name publicly, citing an active federal inquiry running in parallel. Let's get into the actual documents, because this is where the story stops being abstract. Page 19 of the filing lays it out in stark terms. I'll paraphrase closely since the language itself is fairly dense, but the gist is this. Dr. Ashford accessed patient files on 131 separate occasions without any documented medical justification, and in a significant number of those cases, forwarded digital copies through personal unsecured email accounts to individuals entirely outside the hospital system. That's not spin. That's the board's own conclusion. In plain terms, he pulled records he had no clinical reason to look at, then sent them somewhere they were never supposed to go. But page 31 is where things get genuinely uncomfortable. The board's investigators traced the recipient list on those emails. 19 distinct addresses, the majority personal accounts with no connection to any medical institution. 5 of those addresses were later linked, according to investigators, to individuals working in political opposition research. Put those two facts side by side, and you're no longer looking at sloppy record keeping. You're looking at a pattern with intent behind it. I went through this section 3 separate times just to make sure I wasn't misreading it. The timeline the board lays out is genuinely unsettling. February 2024, the first documented instance of unauthorized access. April 2024, the frequency jumps to 4 or 5 times a week. July 2024, Ashford begins accessing files belonging to patients he had never personally treated, every instance logged automatically by the hospital's own server system. Here's the detail that got buried under all the bigger headlines. Page 61 of the report details exactly what triggered the original audit, and it's almost cinematic in how mundane the discovery was. A night shift nurse noticed Dr. Ashford logged into a patient's chart at 3:14 in the morning on a Sunday, a patient who had been discharged nearly 9 months earlier from a department Ashford had no clinical affiliation with whatsoever. Read that back. That's not someone doing a routine follow-up review. That's someone looking for something specific. at an hour designed to avoid attention. The nurse filed an internal report the following morning. Once IT ran a broader sweep, they flagged 78 similarly suspicious access events over the preceding half year. Once that door opened, it didn't close. The consequences moved fast once the audit results reached leadership. The hospital suspended Ashford's clinical privileges within roughly 2 weeks. The state board opened a formal investigation within a month. Federal investigators quietly entered the picture within about 6 weeks of that. And within 8 months total, the number of affected patients had climbed to 51. Exhibit E in the filing breaks down exactly who those 51 patients were. And this is where the political angle really snaps into focus. 26 patients connected to Senator Whitfield's administration or immediate family, 14 patients described as political figures aligned with opposing parties, 7 patients identified as media personalities, 4 described as business associates connected to Whitfield's broader network. Every single name on that list, by the board's own description, was a high-profile individual. Page 72 of the report includes an observation that I think deserves more attention than it's gotten. The board notes that Ashford's access patterns lined up suspiciously well with active news cycles and political events, suggesting the timing of these disclosures wasn't random at all, but strategically chosen. In plain English, whenever one of these people was suddenly in the headlines, their medical file got pulled around the same time. One example from the filing stands out in particular. An unnamed former senior staffer from Whitfield's office had their file accessed 7 separate times over a 2-week window. That window happened to fall right before a high-stakes congressional testimony. Records connected to that staffer were shared with 3 outside email addresses the day before the hearing. 48 hours after the testimony concluded, details from that staffer's medical history showed up in a published news story. Investigators traced the digital trail from Ashford's outbound email straight through to the eventual publication. Not a coincidence, not circumstantial, an actual documented chain. The board described it in its own language as among the most severe breaches of patient trust this panel has encountered in recent memory. And here's the part that makes it genuinely tragic in a human sense. Ashford had spent 47 years in active practice with an entirely clean disciplinary record, right up until 2024. Then everything unraveled at once. That's just from the first document alone. The full report runs 94 pages, backed by well over 200 pages of supporting exhibits. Now let's be fair here, because it would be lazy not to address the other side of this. Ashford's legal team, led by attorney Diane Castellano, a former federal prosecutor herself, is arguing this whole thing reeks of selective enforcement driven by political motivation. And honestly, some of what she's arguing isn't unreasonable on its face. Her first point, Ashford had served as Whitfield's physician for decades, and given how tightly interconnected his patient base was with the senator's inner circle, she argues he had legitimate clinical reasons to stay aware of overlapping health concerns among related patients. Second, she pushes back hard on the unsecured email framing, arguing those messages went to outside medical consultants Ashford routinely brought in for second opinions, not political operatives. Medical privacy attorney Renata Boyle, who isn't affiliated with either side, offered a fairly balanced take on this exact tension. Physicians consult with outside colleagues constantly, and the real question isn't whether consultations happened, but whether they genuinely served patient care or something else entirely. That's a fair point, and I don't think it should be dismissed. Here's what the defense actually has going for it. Ashford did have a long, well-documented treatment history with several of the patients in question, which does support at least a partial continuity of care argument. In fact, buried in the board's own findings is an admission that in 26 of the 131 flagged instances, Ashford had in fact previously provided direct medical care to the person whose file he accessed. That's roughly 1 in 5. The defense argues that's evidence of ordinary clinical practice, not misconduct. Castellano's team filed a lengthy rebuttal, running nearly 45 pages, arguing the board has applied wildly inconsistent standards. She cites 4 other physicians in the state disciplined for comparable conduct over the last 5 years, none of whom lost their license outright. Their sanctions ranged from a 4-month suspension to a modest fine, the harshest being an 8-month suspension paired with a $20,000 penalty. Ashford, by comparison, lost everything in a single vote. The defense brief states plainly that Ashford's well-known political ties appear to be the deciding factor, separating his outcome from every comparable case. Their supporting argument centers on the composition of the board's three-member disciplinary panel, all three of whom were appointed by the sitting governor, who happens to belong to the opposing political party from Senator Whitfield. Castellano argues the optics alone raise legitimate questions about impartiality. Look, I'm not here to hand down a verdict. The board's interpretation is grounded in the actual server logs, which do show access without any documented clinical justification. The defense's interpretation is that political motivations are dressed up in the language of medical ethics enforcement. Both things can be true at once. A genuine violation may have occurred, and the resulting punishment may still be disproportionate to what similar violations have received elsewhere. What the evidence clearly establishes: unauthorized access happened, records left the hospital system, and the timing of those disclosures lines up suspiciously well with political events. Whether that makes Ashford a bad actor or simply an overextended consultant caught in a messy gray area, that's genuinely where reasonable people start disagreeing. The medical board, for its part, didn't seem interested in wrestling with that nuance. They saw a violation, and they acted decisively. The real question moving forward is whether political affiliation shaped how aggressively they acted. That's almost certainly going to be the central argument in the appeal. This whole situation has roots that go back further than most people realize. Years back, Ashford drew national attention for that letter praising Whitfield's physical condition in language most doctors found bizarrely effusive. The medical community reacted almost immediately, criticizing the tone as unprofessional and far outside the norms of standard physician communication. Ashford later admitted, somewhat awkwardly, that portions of that letter had actually been dictated to him directly by Whitfield's staff, which understandably raised questions about where his professional boundaries actually sat. Then, a few years after that, Ashford told a national newspaper that members of Whitfield's security detail had shown up at his office unannounced and left with copies of the senator's medical file without, in his telling, proper authorization. Whitfield's camp characterized it publicly as a routine retrieval of records that belonged to their own client. The incident put a spotlight on Ashford's practice that never fully faded. Medical ethics commentators at the time noted, on the record, that the physician-patient relationship in this specific case appeared compromised by outside loyalties and pressures that shouldn't exist in ordinary clinical practice. And yet nothing formally changed. Ashford kept practicing, kept his ties to Whitfield's circle intact, and kept accessing records in ways that, in hindsight, colleagues describe as having felt off for years without ever quite crossing into something anyone felt comfortable formally reporting. Boundary concerns, quietly noted as far back as a decade ago. Unusual record access, informally flagged by coworkers on more than one occasion. Public comments about patients that raised eyebrows within the medical community. And every single time, no formal consequences followed, not until that one nurse filed that 3:14 a.m. access report. Once that report existed, every ignored red flag from the preceding years suddenly became relevant evidence. Nearly a decade of quietly tolerated questionable judgment, one formal complaint, and an entire career unraveling within months. You can probably see where this is heading. This story isn't really just about one doctor's poor decisions anymore. It's increasingly about how political proximity seems to shape which violations get ignored for years and which ones suddenly trigger the harshest possible response. Friday afternoon, just after 3, is when things actually broke loose. The state medical board convened an emergency closed-door session. The 3-member disciplinary panel voted unanimously, 3-0, to revoke Ashford's license effective immediately, citing what they called overwhelming documented evidence of systematic privacy violations. Board members declined to comment further afterward. What followed happened with startling speed. Ashford's hospital privileges were terminated within the hour. Patients were notified through an automated messaging system before the day was even over. His private practice's phone lines were disconnected by close of business. 6 hours total, start to finish. But here's what most coverage completely missed while everyone was fixated on Ashford himself. Saturday morning, federal investigators quietly announced a parallel inquiry into whether the leaked information had been used specifically to support political opposition research, an allegation that shifts this from professional misconduct into potential criminal territory entirely. Then, on Sunday, Independent investigative journalists managed to identify 3 of the previously unnamed email recipients referenced throughout the board's report. 2 were political consultants. 1 ran an opposition research firm. All 3 had prior work histories tied to campaigns actively opposing Whitfield or candidates he'd personally endorsed. The relevant federal prosecutor's office released a formal statement Sunday evening, indicating they were actively examining whether protected health information had been unlawfully obtained and subsequently weaponized for political purposes. This wasn't a reactive scramble. The coordination between these announcements looks deliberate. Board revocation on Friday, federal announcement on Saturday, journalists identifying names by Sunday. That's not coincidence, that's sequencing. This is genuinely where the story stops being a licensing footnote and starts becoming something much bigger. If formal federal charges eventually follow, this stops being a medical ethics story entirely and becomes a full-blown criminal conspiracy case. And the potential list of people exposed extends well beyond Ashford himself. It potentially includes everyone who received those records, everyone who acted on them, and everyone who ultimately published information sourced from them. That 94-page board report just became a foundational piece of evidence inside a federal investigation. Ashford's medical career effectively ended on Friday afternoon. His broader legal exposure, on the other hand, may genuinely just be getting started. I reached out to several people with relevant expertise to get outside perspective on how significant this actually is, beyond the immediate headlines. A former senior official who spent over a decade prosecuting healthcare privacy violations at the federal level described this as one of the most consequential medical privacy breaches with clear political dimensions in recent memory, comparable in scale to a handful of cases going back decades. In plainer language, this is genuinely rare territory. A medical ethics professor I spoke with framed the board's decision as sending an unmistakable message that political connections don't provide immunity from professional accountability, essentially treating this case as an intentional, precedent-setting move rather than an isolated disciplinary action. Here's something worth noting. Even attorneys who typically work the defense side of medical malpractice cases acknowledged, somewhat reluctantly, that the documentation underlying this case is unusually solid. Server access logs, as several pointed out, simply don't lie about patterns of behavior. When professionals on opposite sides of an issue find common ground on that point, it's usually worth paying attention to. A former assistant prosecutor with extensive white-collar crime experience noted that if investigators can definitively establish these records were shared with the intent to influence political outcomes, that opens the door to genuine conspiracy charges under federal privacy statutes. That's criminal exposure, not simply a civil dispute or administrative penalty. A privacy law specialist who's handled dozens of similar healthcare confidentiality cases put it bluntly: the correlation between record access timing and political news cycles is going to be extremely difficult to explain away in front of a jury. And a constitutional law scholar raised an angle that hadn't occurred to me at all: whether First Amendment protections around political speech might somehow intersect with information derived from private health records, a question with essentially no clean legal precedent to draw from. Across the 6 professionals I consulted, a rough consensus emerged. The medical board acted within its legitimate authority based on documented evidence. A federal criminal case is genuinely viable if prosecutors can establish political intent behind the disclosures. Civil liability for the affected patients is likely and could realistically reach into the millions of dollars collectively. And the appeals process itself could easily stretch out over 1 to 2 years. So where that leaves Ashford is fighting on multiple fronts simultaneously: license revocation, potential criminal exposure, looming civil litigation, and a reputation that's effectively been dismantled, all of it anchored in server logs that, by their nature, can't simply be deleted or explained away after the fact. Let's get practical for a second, because this story isn't just political theater. It has real implications for ordinary people. If you've ever been treated by a physician who happens to maintain connections to political figures, this case is worth paying attention to, because your own records might be more exposed than you'd assume. In this particular case, 51 patients were directly affected, with estimated civil damages already projected somewhere around $2.6 million collectively, which works out to roughly $50,000 per affected patient on average. If you happen to be one of those 51 patients, there's a good chance you're already hearing from attorneys interested in representing a class action. Privacy advocates are recommending that anyone concerned proactively request access logs from their own healthcare providers, essentially checking who's actually viewed their records and when. That's not formal legal advice, just a practical suggestion echoed across the privacy advocacy community right now. This case sets a meaningful precedent going forward. If you ever find yourself involved in anything remotely political, running for office, donating to a campaign, working as an activist, or simply being outspoken online, your medical privacy suddenly carries a new kind of vulnerability it didn't have before. Picture this scenario. You run for a local office seat, and your opponent's campaign consultant happens to have a personal contact inside a hospital system. Suddenly, your prescription history, your past diagnoses, your mental health records, they end up referenced in a campaign mailer. That's not far-fetched hypothetical anymore. This exact case demonstrates precisely how that mechanism could work in practice. The legal framework to eventually prosecute that kind of misuse now clearly exists, but so, unfortunately, does the blueprint for actually doing it. Right now, an estimated 200 individuals connected to Whitfield's broader political network are receiving formal notifications that their information may have been compromised. Patient advocacy organizations are already pushing for mandatory access auditing requirements at any medical facility treating high-profile political figures, with proposed state legislation introduced just this past weekend that could bring formal rule changes into effect as early as next year. Here's the uncomfortable part nobody really wants to say out loud. Political polarization has genuinely found its way into the exam room. If you're publicly affiliated with a controversial figure, regardless of which side of the aisle they're on, you've become a potential target. Your physician might face outside pressure you'll never know about. Your medical history might carry value to someone you've never met. This isn't meant to alarm you unnecessarily, but this case genuinely demonstrates that the risk is real and mechanically possible. So what should informed patients actually be doing? Requesting annual access logs from healthcare providers. Using patient portal systems to periodically check who's viewed their charts. Asking pointed questions before selecting a new physician, specifically around data handling and third-party sharing policies. A few worthwhile questions to ask directly. Who exactly can access my medical records? Do you conduct regular audits of that access? What's your formal policy regarding sharing information with outside parties? Knowledge genuinely helps here, because the same underlying technology that allowed Ashford to access 131 files without justification exists in essentially every hospital system nationwide. The kind of oversight that eventually caught him isn't universally standard practice everywhere. Your medical privacy, whether you've thought about it or not, depends heavily on systems most patients never consider until something like this happens. Now, at least you're thinking about it. Saturday afternoon, Ashford sat down for an interview with a sympathetic media outlet, and if his goal was damage control, it backfired almost immediately. He described the situation as a politically motivated attack that had, in his words, destroyed a lifetime of dedicated medical service. The board's response came Sunday, characterizing his public comments as deeply concerning and reflective of a continued lack of professional insight. Within hours of that interview airing, 3 additional former patients came forward with new complaints of their own. His legal team almost certainly wasn't thrilled about the timing. One privacy law expert I spoke with noted that framing systematic privacy violations as political persecution demonstrates precisely the kind of judgment failure that led to the license revocation in the first place, essentially arguing Ashford's own defense was reinforcing the board's core argument against him. Then, Sunday evening, Ashford posted something on social media that raised even more eyebrows. Without naming specific patients, he wrote that certain uncomfortable truths about people's health would eventually come to light. Reads a bit like a veiled threat, doesn't it? A former federal prosecutor reacted publicly online, only half joking, suggesting someone needed to take his phone away before he handed prosecutors even more evidence voluntarily. By Monday morning, his attorney released a formal statement indicating Ashford would refrain from any further public comment moving forward on the advice of counsel. That probably should have been the very first move, not the third. Instead of things cooling down, the situation kept escalating. Every additional public comment Ashford made effectively became another data point added to the federal investigation file, undermining his own legal defense in real time. A few genuinely open questions remain unanswered as of this recording. First, who specifically requested these records from Ashford directly, and was there any financial arrangement tied to it? The board's report references compensation received for what it vaguely calls consulting services, without specifying dollar amounts or funding sources. Second, why did federal investigators wait until after the board had already acted before publicly announcing their own parallel investigation? The timing strongly suggests some level of coordination between agencies, though neither side has confirmed that directly. Looking ahead, the relevant U.S. Attorney's Office has scheduled a press conference for this coming Wednesday afternoon, specifically addressing enforcement priorities around medical privacy intersecting with political activity. Ashford's legal team is reportedly preparing a federal lawsuit challenging the board's decision outright, with filing expected by the end of this week. Separately, 3 of the affected patients have scheduled their own press conference for Thursday, and their attorneys have hinted at what they're calling shocking new details regarding how their personal medical information was allegedly weaponized. One date worth circling on your calendar: next Tuesday. That's when the board's currently redacted investigative file could potentially be unsealed entirely, assuming Ashford's emergency appeal gets denied. We should have considerably more clarity by then. Let's do a quick recap of exactly where this stands right now. Ashford's medical license was revoked effective this past Friday, meaning he has no legal authority to practice medicine in any capacity. The federal investigation remains active, and its scope continues expanding. Patient notifications are ongoing, with roughly 200 individuals estimated to be affected. Civil litigation is widely anticipated, almost certainly in the form of a class action. Kingsbridge Memorial Hospital has reportedly granted investigators full cooperative access to relevant records. On the calendar ahead, Wednesday brings the federal press conference. Thursday brings the patient's own press conference. Friday is when Ashford's legal team is expected to file their federal lawsuit. The following Tuesday could bring the unsealing of the board's full investigative file, and roughly a week after that, the first formal hearing on Ashford's license appeal is scheduled, though not yet open to the public. One detail still missing from public view entirely: the actual identities of the political operatives who allegedly received these leaked records. Federal investigators are holding that information close, treating it as part of an active criminal probe. Sources close to the investigation indicate subpoenas already went out last week to the 3 individuals identified by journalists, which means, notably, they're no longer being treated simply as witnesses. They're now considered subjects of the investigation itself. The clock is running for Ashford, for anyone who ever received those leaked records, and for anyone who chose to act on what was inside them. The medical board moved first and moved fast. Federal prosecutors are moving considerably slower, but with what appears to be far more weight behind every step. On the surface, this reads like a simple story. A physician violated patient privacy, got caught, and lost his license as a result. But dig even slightly beneath that surface, and this case reveals something much larger about how political opposition research has quietly evolved in recent years. Medical records treated as potential campaign ammunition, server logs functioning as digital evidence trails, and a disciplinary system that appears to apply wildly inconsistent standards depending on who's involved. Comparable violations elsewhere resulted in modest suspensions. This one ended a 47-year career in a single afternoon. I'll be watching that Wednesday press conference closely, because whatever federal prosecutors choose to emphasize will likely signal whether this entire situation remains a contained medical ethics story or whether it evolves into something considerably larger and more consequential. Wednesday, when federal prosecutors finally speak publicly, I'll be right here breaking down exactly what they're really saying beneath the official language. Talk soon.